Good morning, friends. My today topic is today about the delay by the builders in handing over the possession and tentative relief by the National Consumer Disputes Redressal Commission. So, the National Consumer Redressal Commission, shortly known as Ncdrc, comprising President Member Justice R.K. Agarwal, S.M. Kantikar, and Vinod Kumar, while adjudicating on a matter related to the alleged late delivery of property, held that processing the fire NOC and termination of contract with the previous contractor are not valid reasons for the delay in completing of an apartment project. The bench reiterated that the waiting period must be reasonable and the buyer cannot be made to wait for the possession of the flat booked joint indefinitely. Coming to the facts of the case, in 2016, the complainant bought a residential flat in the Emerald Floors Premium project at Emerald Estate in Gurgaon, Haryana, for a total cost of rupees 82 lakh 55,642. The floor was supposed to be handed over within 36 months as per buyer's agreement, but the builder failed to do so. The complainants had paid preferential location charges for a type A ground floor property with a rear and front lawn, but the layout of the lawn was changed without compensating them. The builder issued an intimation of the offer of possession arbitrarily and unreasonably without compensating for the delay. The complainants filed a complaint against the builder for unfair trade practice and seek appropriate relief. Now, the builder argued that the complainants lacked local standing to file the complaint since there was no deficiency in service or breach of the agreement term and conditions by the developer. The respondent further claimed that the complaint was filed to harass the builder and that most of the complaints had already obtained possession. The builder further contended that the delay in completing the project was due to force majeure conditions, that is, act of God, and therefore beyond the builder's control. They also claimed that the opposite party had offered possession to the complainants through a letter of offer of possession dated 13 February 2020. The builder pleaded that the junta was constructed as per the approved site plan and any alteration or modification was carried out on the advice of the architect or engineer with intimation to the complainants. Despite the offer of possession, the complainant did not come forward to take it. Therefore, the builder argued that the complainants are not entitled to any relief. Going into the facts of the case, observation by the Commission, stating starting with the contention raised by the builder that the delay in completing the project was due to force majeure, that is act of God. The Ncdrc held that the grounds mentioned for the delay, such as processing the fire NOC and termination of contract with the previous contractor, do not qualify as act of God. Therefore, the commission was of the view that these reasons are unsustainable. Coming to the second contention raised by the builder that an extension of possession date extension was allowed as per clause 11 subclause B of the agreement and time was not essential. The Commission referred the Honorable Supreme Court decision in the case of Calcutta Best International City Private Limited versus Davis Rudra of 2019 CPJ 29 SC, wherein it was held that the complainant cannot be made to wait for the possession of the booked joint indefinitely. Based on the judgment, the Commission noted that the agreement was signed in 2010 and possession was offered in 2020. After 10 years, the Ncdrc held that such a delay cannot be deemed to be reasonable, and therefore the Commission held that the complainants were entitled to interest compensation for the delay period. The complaint was allowed in part and builder was directed to hand over possession of the apartment to the complainants within 6 weeks from the date of judgment. Additionally, the complainants were awarded compensation in the form of simple interest at the rate of 9%. The case title is Gorbajan and another versus Imar Manufacturing Land Limited, and the case of the number is consumer case number 393 of 2020. Counsel for the petitioner was Mr. Sarvajan and for the respondent Mr. Swatan Santanu and Mr. Pratap Shankar. That's all. So don't worry if the builder is playing fraud with you or knowingly delaying the thing, you can approach the Redressal Commission as per your jurisdiction and pecuniary limits. That's all. Thank you for watching and most welcome to my videos. I am Ashok Arora from Chandigarh.